Have you noticed that instances of conflicting judgments have in the last few years reduced drastically at the Court of Appeal, which used to be the major court of concern? In fact, the last time we heard of conflicting judgments, it was from the High Courts, which were the courts of first instance in the political matters that were brought sometime last year. And even at that, the National Judicial Council, under the instruction of the Chief Justice of Nigeria, has dealt adequately with that situation. But concerning the Court of Appeal, what is the magic that brought about that drastic reduction in conflicting judgments? The scale in this edition spoke with the President of the Court of Appeal, Justice Monica Dongban-Mensing, in an attempt to open up the new strides that have been made at the Court of Appeal. Welcome to The Scale. I am Femi Okeowo. Justice Monica Dongban-Mensing was one of the 6 jurists that were recently conferred with the fellowship of the Nigerian Institute of Advanced Legal Studies, Nigeria's apex legal research institute. Others are Justice Chima Nweze of the Supreme Court, Abubakar Malami, Senior Advocate of Nigeria, Minister of Justice, Professor Awalu Hamisu Yadudu, then Professor Taiwo Shipinton, SAN, and Professor Paul Idonije, SAN. The investiture of Justice Monica Dongban-Mensing as a fellow of NILES gave us on The Scale an opportunity to look at the contributions of the second highest court in the land to the dispensation of justice. And so let's take a bit of the investiture and then we'll go into the interview we had with Justice Monica Dongban-Mensing. What does this fellowship mean to you as a person?
Well, as a person, I think it's an exceptional honor to me, to be conferred with the fellowship of an institution that is meant to, that has been set up to develop the legal profession, And as a jurist, our work is about research, reading, writing, and developing the law. So I find this conferment as a challenge, an invitation to harder work, to look deeper into the law, and to find out how, we can use research findings to develop the law, and for me to heal some of the ills of practice in adjudication, if you understand what I mean.
Yes.
Yes,
you're already moving into the next area where I want to ask. The Court of Appeal must also feel honored that its president has been so honored. How do you think the Court of Appeal will benefit from this honor that has been done to you?
Well, I think the Court of Appeal most certainly stands to benefit to the extent that when we have, worrisome issues, we know that we can refer it to the institute, and they will carry out research, since that is their, area, to find out solutions for us, and map out the way forward, to avoid some of the loopholes that create, some negative issues that seem to be recurring, with our work in adjudication.
Now, years ago, Nigerians used to hear of contradictory judgments emanating from the Court of Appeal. How have you been able to stem the ones that used to come from the Court of Appeal?
Well, the issue of conflicting decisions have actually been, blown out of proportion. You see, as a Court of Appeal, we sit in 20 different divisions, and there's hardly any case that is exactly the same. So the likelihood of variations here and there, in decisions emanating from our different divisions shouldn't really be a big deal. However, how I have approached the issue of, conflicting decisions is to ensure that we watch out for each other. The justices were on the same page. We try to see if a decision has been given, like, all these controversial cases, political matters, commercial matters, or whatever. If we know that it's in an area of likely conflict, we share whatever decision has come up, and we try to discuss it. We have a platform now, thank God, to ICT and all that, and so it's a continuing process. We just keep alert. If any decision comes up, we try and ensure that every justice of the court is put on notice about the existence of this decision. And if you look at our diaries now for this year, we have on each page, or at least on the birthdays of each of the justices of the 89 justices that we have, 88 justices that we have, their pronouncement is published on their birthday. So it will put every justice on notice that the Court of Appeal has made a pronouncement on this subject. So beware. If you have a similar matter before you, make sure you read that decision so that you'll be properly guided. And then, if the Supreme Court has made a pronouncement about our decision, we try to bring it to the notice of all the other justices so that we'll be properly guided.
So a little bit about the focus that we have in the Court of Appeal, and we need it so much, particularly with elections coming up in the next few months. And of course, that the Court of Appeal is the pivotal court by which most election matters are determined. Of course, at a level, there are some levels where it doesn't exceed the Court of Appeal. And at other levels, it goes on to the highest court of the land, the Supreme Court. That is why it's always very important to get things right, as we see is being done at the Court of Appeal. But the event was not only about the investiture alone. It also provided an opportunity for the evaluation of our justice system. One of the inductees, Professor Taiwo Oshikwiton, SAN, delivered a paper on Nigeria's Evidence Act, looking at some developments, problems, and prospects in its decade of operation.
Almighty Section 90, subsection 1C of the Evidence Act, which was also in the old Act. And it talks about if you don't have primary documents, then you can send that secondary evidence. In some other cases, any secondary evidence is admissible, but in this particular case, it says certified copy, but no other secondary evidence is admissible. And the only admissible document of secondary evidence of a public document is certified copy. We all know what public documents are: marriage certificate, death certificate, and so on. Documents brought into being by public officers for use of members of the public. And it said if it's certified, it goes in. It's as good as the original. Problem: what happens when the body that should certify it is unable to certify it? That's what, okay, who should certify it? When we look at goodness and trust, saying that it's the person in legal custody of it, which is a fair decision. The registrar of a court came to tender certified copy of the certificate of incorporation, which was tendered in a case before the court. And they said, no, you cannot do it. That certificate was issued by CAC. You cannot go in. That's a good one. But let's look at Dauda and FRM, the Supreme Court decision. I take it that it will be a positive development if Dauda's case is embraced by all, can be used by the prosecution, and can be used against the prosecution. That was a case in which a prosecuting agency recovered documents while investigating a crime. They took hold of the document. Now, when they were trying to tender, they didn't tender the original document. They tendered a certified copy. And who certified it? That agency. And the Supreme Court said that that document came into lawful custody of the agency. And that's why the agency is not the custodian of the document. That document came into its lawful possession and custody, and you can tender it. Dauda and FRN would seem to be a departure from the earlier decisions, saying that only the custodian can tender it. Dauda and FRN seem to be saying, or appear to be saying, that a person or an agency like ICPC that recovers a document, refusing to tender the original, can certify it and tender the certified copy, despite the fact that it is not the author of the document or the custodian of the document ordinarily. Well, for me, it's a positive development, but to look at the scorecard in terms of reporting back to the House that this is what the message from the Supreme Court is, that anybody or any investigator can get a document, certify it, even if it does not have the original, and tender it.
Now, to conclude our program, let's go into that segment which we recently introduced. We call it You and the Law. How much of a responsibility can we push to our laws as a factor that determines how fast our dispensation of justice is?
I think, speaking for myself, the delayed justice is not a function of the laws. The delayed justice is a function and the problem of the legal profession. I have written somewhere, and I want to repeat it here, that the greatest enemy of the legal profession is the legal profession itself. And the greatest enemy of justice in Nigeria is also the legal profession itself. As you may have heard, the Honorable President of National Industrial Court, the attitude of lawyers and by extension the attitude of our judicial officers have contributed in no small measure to delay justice in Nigeria when the matter is in court. And I speak that the matter is in court. I'm not talking about the other fundamental factors at the side of the executive when it comes to criminal matters in terms of investigation, in terms of the thoroughness and the compromising nature of some of our security agencies. But when we come to court, take for instance, the Administration of Criminal Justice Act has set out how criminal litigations should be conducted from day to day and so on and so forth. But that law does not implement itself. It requires the cooperation of the judge or the judex and the lawyers to do what the law says it should be done. Like I said somewhere else, when we talked about our electoral justice, there is a provision, for instance, in the Electoral Act that tribunal should grant you opportunity to access electoral materials to either to prosecute or defend your case. When you get that order, you now see the frustrating antics and attitude of lawyers because election petition has a time limit within which to conclude. And so all of these things are happening because Nigeria is about the only country that I know that people breach the law and there are no consequences. That is why some persons will just tell you, Femi, I will slap you, and there's nothing you can do. If you like, go to court. Because they know that when you get to court, you will not get justice. Then there is another aspect that I was sharing with my colleagues that we have not even examined. Do you know that it is easier to get judgments in our court and much more difficult to enforce it? Indeed, I will want to see delayed justice from the post-judgments angle because there are many Nigerians who had been...
Let's talk about that. That is frightening.
When you have a judgment against government or government agencies and you want to enforce, you first of all seek the consent of the Attorney General, either of the state or of the federation, before you can execute judgments against government agency. That provision of law is there. Now, opportunity had been there in time past for the judiciary to pronounce that provision dead, but nobody is ready to do so. I only recall sometimes in 1997 or thereabout, when my Lord, the Honorable Justice Ogundere, pronounced the provisions of similar law in Sheriff and Civil Press law of Kano, a military governor of Kano State against Jallo, where his lordship said that execution is part of the compendium of judicial power, and any law that intends to interfere with that execution is unconstitutional. But that was then. But today, some judges still respect that provisions of the law. And the reason is simple.
Is it the judge that tells the beneficiary of his judgment to go seek for the consent of the attorney?
No, when you go to enforce, for instance, there are various ways of enforcing judgment. For instance, you talk about garnishee proceedings. When you trace government money to central bank, for instance, there are 1,001 order made absolute against Central Bank of Nigeria that the Central Bank of Nigeria is not willing to release that money to judgment creditor, despite order absolute in garnishee proceeding. They are fighting the battle as if they are the judgment creditor. Their duty is to release the money. Then, when you talk about physical enforcement, for instance, if you have a judgment against the Senate of the Federal Republic of Nigeria, you would require the police to go and pick the vehicle of the President of the Senate or the Speaker of the House of Representatives, or
even a senator.
Or if a senator himself, or you have a judgment against Inspector General of Police. So in Nigeria, for instance, because there are no consequences for disobedience, the police, the security agencies, and big men have become law unto themselves. So these are part of the reasons why you have what I call delayed justice. Delayed justice is not only to get judgment from court, but after judgment, what is the fruits of the judgment?
So let's look forward. Is there any way out?
The way out is, one, we must repent, all of us. We must have a change of attitude. In order to climb, once a decision of court, every other person must respect it. One, we must respect our judicial institution. Two, we must allow our judicial institution to be independent. Three, the judicial institution themselves must avoid conduct that will bring them into total disrepute. Because once you give appearance of impropriety as a judex, then nobody will respect you.
And it has to do even with our attitude as individuals and as nation. The lawyers have their blame. And when you talk of the lawyers having their blame, you have what I would describe as proper tutelage. The orientation, the philosophy, the mindset of the lawyers being trained in Nigeria must change. That is one. It is those lawyers that now becomes judges, and the beat goes on. If a lawyer with a wrong mentality who gets appointed to the bench will also continue. That is. Then also, the society. There are certain things that the society does to judges, even to the system. People criticize, oh, this one is bad, this one, but the clerk of court, who has been assigned to do certain duties, who is not doing it, it does incalculable damage to the system, to the administration of justice. There's so many things to Nigeria and Nigerians. We must change our mindset about certain things, including the justice system. Then you talk about the appointment, the process of appointment, which to me is also key. The process of appointment should be made to be more transparent. You see, in the world now, people are so much interested in the justice system because the world is so intertwined. Commercial activities in one country has effect in another country. And that is the reason why you now have different protocols. The UN is interested, setting standards. You have the Lilongwe principles, you have the Latima House principles, all pointing out to one thing, all pointing towards one thing, and that is the fact that your justice system, the process of appointment, the process of recruitment of your judges must be transparent. You must have certain standards that judges, the people you appoint as judges must have. So, if we decide to go by those standards and adhere strictly to them, for God's sake, if you know a person is not fit, why appoint him or her as a judge? That is why in certain countries now, interview for judges on television is what they do. You must appear before the JSC. In some countries now, what they do is they don't just thrust you onto the bench of the country, because they know that once you are appointed and you are a liability, you become a liability to the system for long, because judges are not easy to a judge is not easy to remove.
That's the bit we have on the scale today. So many events unraveling themselves, and you can trust that the scale will continue to follow up and get the areas that are of interest to you and to the interest of the development of our law. We'll see you as the days run by. Thank you for being part of today's edition.